And the reason I'm asking, I'm focusing on text messages because I had an interesting client that came in and said, "Well, what if I delete the text messages and that's all we have, and we only have the contract that we signed, but the text messages, you know." So what do you caution clients when they start trying to suggest things that you and I both know are not the best approach to things?
Well, obviously, first of all, that's a big ethical problem. And no ethical attorney is ever going to advise their clients to destroy anything. But there are also practical ramifications for that, even if the potential client's ethics are less than upstanding when it comes to that. Because, for example, there are ways to recover text messages from the service provider, for example. So somebody could send a subpoena under certain circumstances to get that information directly from, a Verizon or whomever happens to be the carrier. And if it is discovered that you basically, not you, but the potential client actually tried to destroy or make evidence unavailable, that's called spoliation of evidence.
Oh,
And a court has the ability to take all sorts of punitive action, which would involve, essentially to the point of you would lose the complaint and may get sanctioned by the court, meaning you'd have to pay a lot of money for having done that. So it's a terrible idea to try and cover your tracks by getting rid of things that are maybe a little less helpful.
and one of the things that got came to mind, the reason I even brought it up is because I was trying to tell the client that, listen, if we go into litigation and this is the judge that's going to be overseeing your matter, if you lose credibility with that judge with doing things like this, guess what's going to happen? They're gonna like not trust anything that's coming. The credibility goes away. In your experience, is that hold up? What have you?
That's a tremendous point, Sanjay. Having done this for as long as I have, one thing I have always been very cognizant of is that your reputation is very important, particularly, while yes, there are a lot of attorneys. I practice in Orange County, LA County, all around. Sure. So there's a lot of judges, a lot of attorneys, but I can tell you that it's commonly known judges talk and judges form opinions on who appears before them. How professional are they? Do they tell you the truth? Do they stick to what if you're asking them a question? Do they answer the question? Do they make your life more difficult or easier? And you build up a reputation, and it's always been very important to me to make sure that I protect that reputation because then it works to the benefit of my clients. Because then when I go before a judge, they're going to say, okay, I know Mr. Francisconi is going to tell me the truth. And he's going to, deal with me in a straightforward manner, and he's not going to play games with me. This is important, and my clients benefit from that. So and to a smaller degree, but a very important degree, it's important for the clients, for them themselves, to have that level of credibility with the court, because you have to remember that judge is going to be making decisions about your case. So the last thing you want to do is have that judge not believe you. Because at some point, if you're going to go to trial and that judge is going to make credibility determinations about you, and they know how you've played the litigation up to that far, that you haven't been a straight shooter, then that's something that a court's going to hold against you.